Our next case is People versus Kardasz. Mr. Wright, stay right there. This is a 15-minute mini oral argument on the application. And Mr. Zaman and Mr. Rastusha, you are splitting time, 10 minutes and 5, and you know you're going to keep track of that yourself. I'll probably remind you as well. You both have 2 minutes of a free fire zone, which you may waive, and you may reserve time for rebuttal, but we ask that you keep track of that yourself. And you may begin when you're ready.
May it please the Court, Ali Wright from the State Appellate Defender Office on behalf of Mr. Kardasz. I'd like to reserve 2 minutes for rebuttal. 2021 SORA is punishment because nearly all the punitive portions this Court identified in Betts remain, and the features that made it punishment in Lyman apply equally to sexual offenses. 2021 SORA is not just punishment, but it is also cruel or unusual punishment under this Court's test in Bullock, and after this Court accounts for the evolving standards of decency that mark the progress of a maturing society. The mandatory long periods of registration up to life, the immediate in-person reporting requirements, the public nature of the registry, which contains extensive personal information about registrants and automatically pushes out passive geo-tracking alerts to the public, the lack of any individualized assessment, and the lack of any ability to petition for removal all contribute to a constitutionally infirm statute that this Court must strike down. In foreclosing any individualized assessment, SORA has resulted in the creation of a registry that is bloated and does not reflect who is truly at risk of committing a future sex offense. The government should want precision. This Court should want precision. And the people of Michigan should want precision. Those who truly pose a future danger to society should be required to register under a constitutional statute. But the solution is not to cast an overly broad net and subject those who may not be at future risk of reoffending to the same punishment that is physically and mentally debilitating. I'd waive free fire at this point in time and welcome questions from the Court. Oh, well, that's 2 minutes anyway. The bullet factors show that 2021 SORA constitutes a cruel and unusual punishment for its 40,500 plus registrants.
Counsel, what's your response? The people have argued that essentially the problems have been fixed, that the current 2021 SORA is really just like the federal SORNA law. That's largely been upheld, so how do you respond to that?
Well, for one, our constitutions are different. Our state constitution can be and has been read differently by this Court than the federal constitution. And two, I'd say no, the problems have not been fixed. While the physical exclusion zones were removed from 2011 SORA, this Court still held in Betts that some of the changes were more ameliorative and some were more restrictive. And again, I'd point to the 5 things: immediate in-person reporting requirements, the public nature of the registry, mandatory long periods up to life of registration, no individualized assessments, and no ability to petition for removal, that still make 2021 SORA run afoul of our Constitution. And so until those things are fixed, we still have an unconstitutional statute.
And are you making a facial challenge here? Is the whole statute unconstitutional?
Correct. It's a facial challenge as well as an as-applied challenge, but it's definitely a facial challenge as well.
Okay, thank you.
And Counselor, wouldn't we need a thicker record with respect to your particular client and his risk to make an accurate as-applied challenge?
As applied to him, potentially, I'm not sure. I think this Court can still rule on the facial bit, and if it's facially unconstitutional, of course, that would be unconstitutional as applied to Mr. Kardasz. So I do think the record as is sufficient for this court to reach a ruling on the constitutionality of 2021.
But if we do not reach that it is facially unconstitutional, and we are just looking at as applied, I think what Justice Thomas is asking is, do we need more for your client in this case to make that determination?
There's been no individualized assessment of Mr. Kardasz or his risk of reoffending in the future, and so ideally that would occur before a court could make an assessment as to whether lifetime registration is appropriate, among other things.
Thank you.
Just briefly, with respect to the Bullock factors, the first and fourth, registration serves as a scarlet letter that brands registrants. It impacts them in every aspect of daily living, from their jobs to their housing stability and situations, their physical or mental health. It subjects them to scams, and it impacts, honestly, all of their social interactions with family, friends, colleagues, and loved ones. The immediate in-person reporting requirements are onerous, and all that contributes to making 2021 SORA overly harsh because the punishment is never tailored to the person. Also, again, with respect to the fourth factor, jeopardizing registrants' physical safety, they're subject to acts of vigilantism, and I'd particularly call the court to the attention of the example in the brief of KN, whose employer made sexual advances at her once he found out she was on the registry, and when she rebuffed those advances, her employer assaulted her physically in front of staff and said it felt, quote, freeing to assault her. The registry should not serve as a catalyst for cathartic violence. And it also erects many barriers to human connection. There were examples of people who could not even attend their father's funeral out of state because of fear of being sent back to prison or fear of running afoul of the requirements. With respect to the second and third Bullock factors, other than lifetime electronic monitoring, there are no mandatory lifetime post-incarceration punishments in Michigan. With respect to the penalty imposed, it's only 18 states. And as this court held in Parks, where 17 states had LWOP, in addition to the federal government, even if Michigan is not an overwhelming national outlier, the Michigan Constitution still does not permit excessively harsh punishment. So with that, SORA meets the test that this court set out in Bullock. It constitutes cruel or unusual punishment. And Mr. Kardasz asks that this court strike down LEM and the SORA statutes. I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good morning, Your Honor. May it please the court, Emil Sama on behalf of the people. I will waive my free fire zone and, of course, answer any questions immediately. Given the argument just before us and this argument today, there are a couple of things I really want to touch on that covers all these things. Whether or not this is unreasonable, whether it's intrusive, whether it passes the test, whether there's individual assessment, I think we look at everything from a perspective that we have to remember that these cases, where they're required to do SORA, LEM, are the worst of the criminal sexual conduct cases. Lifetime registration applies for CSC first degrees and for very specific other crimes under the different tier system. Now, CSC 4, it's not improper touching, these are ones. And Mr. Kardasz specifically doesn't qualify for a lifetime CSC 1, no one really does. This is a man who at 30 years old violated his 5-year-old daughter repeatedly until he was finally caught when she finally had the courage to report to her mother. The father who's supposed to protect their child became the monstrous nightmare to that child. So I think what you have to look at in this situation is what is reasonable here, not only for LEM, not only for SORA, not only for all of it, but I think the question that Justice Kavanaugh asked is when we look at stuff that regular law-abiding citizens do not have to do versus somebody who is not, yes, there's going to be differences. They must be. And it is constitutionally reasonable to have those differences. Felons lose a lot of their privileges. They can't vote. They can't hold guns. They can't possess guns. And yes, there's been an argument that violates the Second Amendment, but there is still restrictions on everybody. And the restriction that applies is less intrusive than prison. The fact that they have to register on a quarterly or semi-annual basis to update their address is not so intrusive as to make it cruel or unusual punishment. The fact that they have the proverbial scarlet letter doesn't really apply either. The scarlet letter happens when anybody who can do a public record look for any person on the internet now for $7. You'll find out they're a sexual offender on that alone, irrespective of SORA. And the idea that doesn't apply to recidivism rates, and here's why I always have issue with the recidivism rate, especially the percentages that come up from both sides. And I liken it, I analogize it to areas of high crime, where there's been a high crime area, and in response to that high crime area, they increase police presence, and then the high crime area now becomes a low crime area. And then when the next budget meeting comes around, they argue to slash the funding because, well, there's no more crime there, so you don't need as much police there, and then the crime comes back when you remove it. I think LEM and SORA both have a very specific purpose, and that purpose is not only to protect, to deal with recidivism, it's to put people on notice, as well as there are certain consequences to your actions. And those consequences only come for the most serious. Not just because you touch somebody, you bump into somebody, you copped a feel. This is, especially in this situation, where you have somebody who repeatedly raped their 5-year-old daughter. To say that SORA is disproportionate to him, there is no one SORA could ever be proportionate for. And I think the Does v. Whitmer case really dealt with the idea of the individualized assessment and the impracticality of it on every situation, especially if you're trying to say, well, maybe 30 years on the line, we start to do individualized assessments. I think that is going to be something the legislator may have to potentially do, and that's something that could be addressed by the legislator. But it's one, the fact that it's mandatory does not make it cruel or unusual, because as the Does judge said very specifically, what happens if you get it wrong? And they go back and recidivate and assault and sexually assault more people. The fact that they are stuck in a situation where they can't go to certain areas because of what their crime entailed. Restrictions on certain people because of crimes that they've had, being felons, is not new. People who have criminal records can't always travel to Canada. They can't always travel overseas. We don't argue to vacate their conviction because of that collateral consequence. And no one's saying these people cannot travel anywhere out. So the question, they're afraid of traveling to other areas, really, it seems to hold a very hollow ring to it compared to the lifetime pain and suffering that a minor and victim has to go through. So I think on balance, it is not constitutionally cruel or unusual, even under our statute, under our Constitution. And given that, I'm going to give the rest of my time to Mr. Restuccia.
Thank you.
Good morning.
Morning.
May it please the court. Eric Restuccia from the Attorney General's Office, appearing on behalf of the Michigan State Police as amicus. In my few minutes here, I'd like to make 2 points regarding the SORA question. The first is this is not the right case in which to resolve the threshold question about whether the 2021 SORA is punitive. Regardless of your review of the 2021 SORA, it is not unconstitutional to apply its requirements to Robert Kardasz, who is the gravest of offenders, having raped his 5-year-old child. Second, this case is also not in the right position to address the broader issue about whether it's cruel or unusual punishment, because if somehow this court thought it might in fact be cruel or unusual punishment as applied to Mr. Kardasz, there's been no briefing on the significance of such a ruling. If Mr. Kardasz is arguing that he comes off the registry, which it appears to be this morning he does, is he arguing that the registry should apply to no one? That all 45,000 registrants should no longer have to register? The implications of such a ruling has not been briefed and could be potentially devastating to the registry. All right, on the first point, about why this is not the right case to resolve the
So,
threshold
Counselor, I
issue.
do want to ask about, in
Sure.
your brief, you suggest that the punishment question, if resolved in this case, is a slightly different question than the question under the Equal Protection Clause, and I would invite you to elaborate on that. Are you saying that the application of the Mendoza-Martinez factors are different in this case, or that once there's a decision on punishment, the subsequent questions are different questions that the court answers?
Yes on both. So on the first, they're different tests. They're the same test, the Mendoza test, obviously, and we've been pressing on that point using the federal case law. But the legal claim is different in kind. One's cruel or unusual punishment, one's equal protection.
Yes, but the punishment inquiry, is the punishment inquiry
Right,
exactly
the
the
punishment
same?
inquiry looks the same, but then when you look at actually the set of obligations that are at issue for the retroactive punishment claim, 725-2 of the statute doesn't require offenders who are convicted before 2011 to update information regarding internet information and email addresses. So already there's a difference in obligations. And 2011 is generally the kind of the hinge, because that's when all of the obligations that this court found to be punitive came in 2006 and 2011. But
And you agree Mr. Kardasz is to be evaluated under 2021, even though his
Right.
conviction and sentence were earlier?
right, so the way the registry operates, in fact, there have been, as I, in the briefing, it's been amended 15 times. Each time it's amended, the obligations arise from the law as it exists, not at the time in which the conviction occurred. So that the current registry, everyone is uniformly obliged under the 2021 law, but the obligations of the pre-2011 offenders are different. And then, if you're doing an ex post facto analysis, the question is what punishment has been applied retroactively. For example, the periodic in-person reporting obligations that occur quarterly, those came in 1999. So if I'm a 2005 sexual offender, really the question is what is new to me and what would be my claim? So the question for Mr. Kardasz, who has all of the obligations, are different in kind from the issues about whether it's punitive for him as against a 2005 offender, even a 1995 offender. It wouldn't answer the question. And also, there is a published Court of Appeals opinion from October that says that SORA is not punitive and not an ex post facto violation.
And so I wanted to ask you about that. So if you're suggesting we pass on that question, in light of that published decision, does that change the analysis on?
No, I think, in a way, I think this, because the second part of your question was, well, what then follows? Because I'm arguing here, what then follows has not really been sufficiently briefed. If this court is really seriously considering to think Mr. Kardasz is cruel and unusual punishment, in my view, this is not a close question. He could be given a life sentence, it would not be cruel or unusual punishment. So the idea that he has to register, that doesn't seem like a close question. That's obviously my view, and I'm a prosecutor. But if this court did think it was a close question, it would be incumbent on the court to know what would follow from that ruling, firstly. And then the same is true with respect to the Johnson case, where both the issue whether it's punitive for ex post facto purposes and then what would follow from it are in play. And it seems to me, if the court had ruled it was punitive, then you'd have to reach the issue of severance. The idea of doing a piecemeal analysis, so here you have the cruel and unusual punishment, and then what's going to happen, and there's claims about individualized assessments. And then you have a comparable issue pending in Johnson. The idea that you would not resolve those at the same time. In fact, one of the things we tried to do is push Johnson forward once the Doe's 3 decision came down. And in fact, I think the Court of Appeals decision further shows the importance of resolving Johnson. I think, strictly speaking, if I were on the Court of Appeals, I would feel bound to follow Kuczynski, even if this court said it was punitive in this circumstance, because Kuczynski is the one that governs the specific conduct that's at issue for the ex post facto analysis. In other words, a decision on whether it's punitive would not resolve the questions. So I think my first answer, what should happen here, if Mr. Kardasz loses, it's not cruel or unusual punishment, irrespective of whether you think it's punitive. And then you take the Johnson case and resolve it. Whereas if this court really thought, boy, this may be cruel and unusual punishment, which I don't think it's a close question, but if the court did, I think it would make sense for it, this is an argument on application, set this case over for the next term, grant Johnson, have all those issues heard together so the court can provide one comprehensive answer. Because really the kind of confusion that's created by having Kuczynski sit, which still would be binding in my view, if this court did say it was punitive. But even on that point, I want to push back because I think there's almost a sense that we're going to lose on the question of whether it's punitive. The Court of Appeals has applied Lyman and said it's not punitive. Even the Doe analysis, finding it to be punitive, frankly, supports further the decision that the SORA is not punitive. And I want to make maybe just a few points. I'm not sure if the court, no, I'll press on that point. It's not necessarily responsive to your question. Michigan's SORA is now substantively virtually identical to SORNA. That was the whole point of the 2021 amendments. The Sixth Circuit, in kind of a passing reference, said all of the constitutional infirmities have been addressed. Now, obviously, Judge Goldsmith has come in, and in fact, he ruled that it was punitive, and then the question of what that would mean, you read his footnote 31 on page 38, suggests that the in-person reporting that came in 2011 can't be applied, but he hasn't issued his final judgment yet, so we're waiting on that. But the point, though, is, in his opinion, he cast doubt. In fact, he rejected the claim about individual determination. One of the things he cited was, one, because it was an equal protection and due process claim with respect to individual determination in that case. One is he referenced the possible, potentially towering costs, because the Michigan State Police expert said the cost of doing an individual determination for all 45,000 registrants would be between $350 million and $880 million.
But isn't the static 99 done for every sex offender already within the
It's done
Department of
for
Corrections?
parole on an individual basis. In other words, it's done on like the number of static 99Rs that are done. And even that, I think, is kind of the, well, I'll finish the answer to that. So the idea of doing all 45,000 and making that a prerequisite, I mean, if you read, I encourage the court to read again the Smith versus Doe case, because this very analysis, they said you can make reasonable categorical judgments in Michigan, the United States Supreme Court, in an analysis regarding whether it's punitive, push back on the very thing that we're hearing here, which is precision. It said you don't need this close connection. It's not this kind of strict scrutiny analysis that's in play. It's a very different kind of analysis, one that makes the rational relationship to the non-punitive purpose the focus, because I think the piece that has been underemphasized, or at least not, I don't know if it's been fully appreciated by the court, is the nature of the registry is not about, in its central function, changing the conduct of those on the registry. It's about giving information to ordinary persons so they can make decisions for themselves and their families. This information is already all over the internet. Insofar as they pressed on this issue of shaming, and when I pulled up Robert Kardasz in my Google function, the first 10 entries, there was no reference to the Sex Offender Registration Act. In fact, it was this court's opinions. His conduct is known to the community through the internet, irrespective of the registry. The registry is like this place where you go and you can find, I think the analogy back to the 2003 go to the archives is right. There's a sea of information on the internet. My ability to find this, I have to actually go into the registry and pull out his information. It's for me and my family. In fact, the people who are I say me, it's not really me, because I'm not going to look at it, because I'm not afraid of being victimized by a crime. I'm a man in my mid-50s, right? And people have this ability to get this information if they're willing to go through a paywall. This is for people who are poor, who have limited means, who want accurate information so they can make decisions. And I'll say one more thing, because one of the questions was asked about this 10% reconviction rate, because obviously once you realize that only some number are reported, and then a number of that, how many arrests occur, and then how many are charged and how many are convicted. I mean, you get 10% reconviction, you're at a much higher percentage, 25, 30, 40%. And of course that's true for other crimes, I get it. But the idea that this crime, if you talk to people in the community and say, we should have a breaking and entering registry, I mean, they would be puzzled by it. Victims of sexual offenses, it is so, it's like a murder. It's like being, the comparable gravity is like murder. So if we said, well, there's a 25% or 20% re-murder rate, that's okay, because other crimes have it. People would blanch. These are the most serious crimes. In any event, I think I've gone beyond my time, and I see I should stop talking now, but I'll say one last thing. I would encourage the court, if it's seriously considering finding Mr. Kardasz's obligation to register being cruel or unusual punishment, it should fully grant the case, ask for further briefing on the question of what the relief would be if he's going to prevail on that, and take the Johnson case, hear them together. Provide one
But counsel,
uniform answer.
just a quick question, though. There is no SORA requirement for murderers.
Yeah, because murders don't generally get out. You commit first-degree murder in Michigan, you get a life without parole sentence.
No, but I mean like manslaughter or something of that nature.
Well, it seems to me that generally the perception of the community is that, and it's true, is that sexual offenders will be released back into the community in ways that murderers will not. They get lifetime without parole sentences. The Department of Corrections probably has 2,000 different life sentences. In fact, that's one of the things the court has seen with the juveniles, right? I remember at the last argument, someone said there's going to have to be 590 resentencings. Now, we're just talking about 18, 19, and 20-year-olds, or whatever the range of time was. The community thinks that murderers are going to stay in, and frankly, the nature of murder are circumstances that are often within your control, whereas sexual offenders, even though known to you, the nature of sexual offenses are different in kind, because the very thing that has been stated here is they are often known to the family, but they're not known to be sexual predators. And that's the piece that has to be known. To bring someone in who you don't know has a sexual past, a crime of sexual past, the idea you would have a babysitter. Anyway, I'm past my time. Thank you.
You are. Thank you very much.
I'd like to respond to a few things from both brother counsels. First, I believe brother counsel said that anyone can do a public search. And, sure, that's true, but, and I assume he's meaning about through the court dockets, maybe through iChat, but those, the search of public court websites, those public searches, they don't send out automatic geo-tracking location information on people. They don't provide, the registry provides significantly more detailed information about those who have to register than what would be found on a court website, their employer, their internet identifiers. So I think these are different, or night and day in that respect. And then also the way the registry is being used, people are not posting the court's websites on social media and saying, so-and-so is going to be here, and maybe we should take matters into our own hands. They're posting links to the registry. And I believe brother counsel also said that when he searched for Kardasz's name, it's the court's opinions and the Court of Appeals, this court, are the first things that come up. I searched the first top 10 sex offenders listed on registry, just in alphabetical order, and the first thing that comes up for them is the sex offender registry, not their cases. So I think that those are different, and this court, I refer this court back to its decisions in Betts and in Lyman. This court said that a public website, a public registry is different than a trip to the archives or a record search, and that's very true. The public SORA's registry or registry website is very different in that respect. And secondly, I'd also point out that I believe both brother counsels said this, that SORA is limited to the most serious offenses. That is not true. SORA is not limited to the most serious. It covers a whole host of CSC offenses. And that's why there's 40,000 plus people on the registry.
I heard them say that LEM was limited to the most serious
so maybe I
offenses.
misheard. Maybe I misheard.
But to the point that they made about your client in this case, and if they if they shouldn't be on SORA, then no one should. What is your response to that?
My response is that there's been our position is that no one should be have to register. That's never been our position. Our position is that no one should be subject to an unconstitutional statute. So the legislature, I believe I said this for its members, I'm sure there are many lawyers, they can come up with and devise, and this is their job, to enforce or enact a constitutional sex offender registry statute, but that's not what we have currently. And so SORA should be struck down for everyone in its current state, and the legislature needs to enact a constitutional statute. And so I think that also answers Brother Counsel's question of, well, what happens? What happens is everyone comes off the registry and the legislature imposes a fix. And that's what they did with 2011. They did it very quickly with 2021 SORA, and they can do it again. And hopefully this time it will be a constitutional one. So we're not asking for this piecemeal approach. We're asking that this court strikes it down and it applies to everyone, and there's no need for this court to wait on a resolution in Johnson. Lyman and the principles underlying Lyman should be extended to Kardasz with respect to punishment. So, and then I guess just, I believe Justice Welch, there was some conversation about federal SORA. I think you might have asked both of us about that. I refer to the court, I'd refer the court to its decisions in Betts and in Lyman, which did address, which did not adopt the prosecution argument with respect to federal SORNA, and talked about it not being fixed with 2021 SORA. So I think the court can look at its decision in the language there in Betts and Lyman for that. Just a couple more things. One would point out, I think Brother Counsel said that felons cannot vote. I don't think that's true. I think they can vote. But more importantly, there was discussion about murderers or people who have committed murder, and we do not make them register in this way. And I would point out that people who are convicted of murder, whether it's from manslaughter or second degree, an imposition of LWOP is not always the case, and people who have been convicted of murder are released back into the community routinely. And we do not monitor or make them register like this. And oftentimes those crimes impacted people directly around them, just as a sex offense might impact people directly around you. So I don't think there's a distinction there. Unless there's any other questions from the court, we'd ask that this court strike down the LEM statute as well as the SORA statute.
Thank you very much. Thank you both, and the case will be submitted.